Last 5 seconds. Ready, start. This court in a judgment reported as Dr. Subhas Kashinath Mahajan versus State of Maharashtra and another 2018 6 SCC 454 issued certain directions in respect of investigations required to be conducted under the Act. In a review filed by the Union against the said judgment, this court in a judgment reported as Union of India versus State of Maharashtra and others 2024 SCC 761 reviewed the directions issued by this court and held that if there is a false and unsubstantiated FIR, the proceedings under section 482 of the code can be invoked. The code held as under. There is no presumption that the members of the scheduled caste and scheduled tribes may misuse the provisions of law as a class, and it is not resorted to by the members of the upper caste or the members of the elite class. For lodging a false report, it cannot be said that the caste of a person is the cause. It is due to the human failing and not due to the caste factor. Caste is not attributable to such an act. On the other hand, members of scheduled castes and scheduled tribes, due to backwardness, hardly muster the courage to lodge even a first information report, much less a false one. In case it is found to be false, unsubstantiated, it may be due to the faulty investigation or for other various reasons including human failings irrespective of caste factor. There may be certain cases which may be false that can be a ground for interference by the court, but the law cannot be changed due to such misuse. In such a situation, it can be taken care of in proceeding under section 482 CRPC 1973. Later, while examining the constitutionality of the provisions of the amending Act, Central Act number 27 of 2018, this court in a judgment reported as Prithvi Raj Chauhan versus Union of India and others 2024 SCC 727 held that proceedings can be quashed under section 482 of the code. It was held as under. The court can in exceptional cases exercise power under section 482 CRPC 1973 for quashing the cases to prevent misuse of provisions on settled parameters. As already observed while deciding the review petitions, the legal position is clear and no argument to the contrary has been raised. In Garage Pentia, one of the arguments raised was non-disclosure of the caste of the accused, but the facts were almost similar as there was civil dispute between parties pending and the allegation was that the accused has called abuses in the name of the caste of the victim. The High Court herein has misread the judgment of this court in Asha Bhai Machindra Adagale as it was not a case about the caste of the victim but the fact that the accused was belonging to upper caste was not mentioned in the FIR. The High Court of Bombay had quashed the proceedings for the reason that the caste of the accused was not mentioned in the FIR. Therefore, the offence under section 3(1)(11) of the Act was not made out. In an appeal against the decision of the Bombay High Court, this court held that this will be the matter of investigation as to whether the accused either belongs to or does not belong to scheduled caste or scheduled tribe. Therefore, the High Court erred in law to dismiss the quashing petition, relying upon larger bench judgment. The appellant had sought quashing of the charge sheet on the ground that the allegation does not make out an offence under the Act against the appellant. The appellant had sought quashing of the charge sheet on the ground that the allegation does not make out an offence under the Act against the appellant merely because respondent number 2 was a scheduled caste, since the property dispute was not on account of the fact that respondent number 2 was a scheduled caste. The property disputes between a vulnerable section of society and a person of upper caste will not disclose any offence under the Act unless the allegations are on account of the victim being a scheduled caste. Still further, the finding that the appellant was aware of the caste of the informant is wholly inconsequential, as the knowledge does not bar any person to protect his rights by way of a procedure established by law. This court, in a judgment reported as Ishwar Pratap Singh and others versus State of Uttar Pradesh and another 2018 13 SCC 612, held that there is no prohibition under the law for quashing the charge sheet in part. In a petition filed under Section 482 of the Code, the High Court is required to examine as to whether its intervention is required for prevention of abuse of process of law or otherwise to secure the ends of justice. The court held as under: having regard to the settled legal position on external interference in investigation and the specific facts of this case, we are of the view that the High Court ought to have exercised its jurisdiction under Section 482 CRPC 1973 to secure the ends of justice. There is no prohibition under law for quashing a charge sheet in part. A person may be accused of several offences under different penal statutes, as in the stent case he could be aggrieved of prosecution only on a particular charge or charges on any ground available to him in law. Under Section 482, all that the High Court is required to examine is whether its intervention is required for implementing orders under the Criminal Procedure Code or for prevention of abuse of process or otherwise to secure the ends of justice. A charge sheet filed at the dictate of somebody other than the police would amount to abuse of the process of law, and hence the High Court ought to have exercised its inherent powers under Section 482 to the extent of the abuse. Stop.